Mental illnesses in correctional facilities have been a serious and growing challenge throughout history. Jails and prisons have increasingly become institutions that often house a major percentage of individuals that suffer from mental illnesses. In response to crime, the punitive movement was embedded into the criminal justice system. Societies have used jails and prisons to detain individuals who have been accused of alleged crimes or to adhere to misconduct as punishment. This situation raises critical questions about the legal responsibilities, inmate rights, and the role of correctional system in providing mental health care. The legal foundation for addressing mental illness in correctional settings is rooted in the Eighth Amendment, which prohibits cruel and unusual punishment. In Estelle v. Gamble in 1976, the U.S. Supreme Court established that deliberate indifferences to an inmate's serious medical needs, including mental health needs, violates the Constitution. In the landmark case Brown v. Plata 2011, further reinforced these principles.
How does the Eighth Amendment's prohibition against cruel and unusual punishment apply to medical treatment provided to prisoners? The United States Supreme Court diagnosed those constitutional standards in Estelle v. Gamble. A bale of cotton fell onto J.W. Gamble, a Texas prison inmate, as he unloaded a truck. A prison medical assistant checked him for a hernia and sent him back to his cell. Gamble's back pain grew more severe, and he was subsequently diagnosed with a lower back strain. Over the next 3 months, he was examined by prison doctors and medical assistants 17 times for back pain, high blood pressure, and heart problems. The doctor ordered he be moved from an upper bunk to a lower bunk for a week, but prison authorities didn't reassign him. A few weeks later, despite continued pain, the prison doctor certified that Gamble was fit to resume light work. When Gamble protested that his back hurt too much to work, he was placed in solitary confinement. The prison doctor prescribed medication for high blood pressure, but the prescription went unfilled for 4 days after the staff lost it. 3 months after the initial accident, while still in solitary confinement, Gamble complained of chest pains. A day later, the doctor performed an electrocardiogram and prescribed medication for an irregular cardiac rhythm. 5 days later, after 3 days of continued chest, left arm, and back pain, and having guards refuse his request to see the doctor, Gamble finally saw the doctor, who extended his cardiac medication. Gamble filed a handwritten petition in federal court against Director of the Texas Department of Corrections, W.J. Estelle, and 2 other corrections officials, pursuant to Title 42 of the United States Code, Section 1983. Gamble alleged that his treatment violated the Eighth Amendment. The district court dismissed Gamble's petition for failure to state a claim, but the Fifth Circuit reversed. The United States Supreme Court granted cert.
Prior to 1995, many federal courts remediated unconstitutional prison conditions by issuing structural injunctions, which order government institutions to comply with constitutional requirements. Concerned about the scope of such injunctions, Congress adopted the Prison Litigation Reform Act of 1995, or the PLRA. In Brown v. Plata, we explore the PLRA's restrictions on structural injunctions that combat prison overcrowding. For more than 11 years, California's prison system operated at almost 200% capacity. During that period, 2 federal class actions alleged that state prison conditions constituted cruel and unusual punishment, violating the Eighth Amendment. In Coleman v. Brown, prisoners with mental illnesses alleged that a shortage of space and staff resulted in extended delays for mental health care. The district court appointed a special master to oversee remediation, but 12 years later, the special master reported that conditions were worsening due to overcrowding. In Plata v. Brown, prisoners with serious medical conditions alleged that a lack of staff and equipment resulted in inadequate medical care. The district court issued a structural injunction and eventually appointed a receiver to oversee remediation. But the receiver reported that rampant overcrowding precluded improvement. Because overcrowding hindered remediation in Coleman and Plata, the plaintiffs in each case moved to convene a 3-judge district court under the PLRA that could order a reduction of the prison population. The requests were granted, and the cases consolidated. The three-judge court ordered California to bring the prison population to within 137.5% of the prison system's capacity. Although the order didn't stipulate how the state must meet that goal, the order effectively mandated the release of up to 46,000 prisoners unless California built additional facilities or arranged out-of-state transfers. California appealed to the United States Supreme Court.
State regulations also provide guidance on inmates' mental health care. For example, the California Code of Regulations, Title 15, Article 9, Section 3360 through 3369.1 outline procedures for screening, treatment, and monitoring of inmates with mental health conditions. These rules aim to create consistency and accountability within the correctional health system. In an exploratory study, researchers study psychopathology and history of mental health care among male detainees transferred to a facility for managing otherwise uncontrollable in-prison violence. The research examined 292 male detainees incarcerated at the violence facility in the Netherlands between the dates of January 26 through 2022. The information was detained by the Dutch Ministry of Justice. It states that 253 male detainees were examined by a psychiatrist for psychopathology assessments, and 252 of those detainees were diagnosed with at least one psychological disorder. Researchers further examined that most prevalent psychological disorders among detainees are intellectual disability, with 56, attention deficit hyperactivity disorder, with 92, psychotic disorder, 38, substance use disorder, 102, and personality disorder, 103. These statistics demonstrate how detainees are diagnosed with multiple mental health disorders and are not receiving adequate treatments to mitigate violence in prison induced by these disorders. According to a survey conducted in 2016 by the U.S. Department of Justice Bureau of Statistics, an estimated 41% of state and federal prisoners aged 18 and over self-reporting having a history of a mental health problem. Improving mental health care behind bars requires a multifaceted approach. First, correctional facilities must increase access to qualified mental health professionals and evidence-based treatments, including therapy and medication management. Early screening upon intake is essential to identify individuals in crisis or at risk for self-harm. Second, facilities should establish specialized units or programs for inmates with severe mental illnesses. These units provide a structured, therapeutic environment that reduces the risk of harm to both inmates and staff. Collaborations with community mental health agencies is also critical to ensure continuity of care upon release, which helps reduce recidivism. Finally, staff training is key. Correctional officers and mental health providers need proper education on recognizing signs of mental illness and responding appropriately to de-escalate crisis and prevent abuse or neglect. Mental illness behind bars is a complex issue with legal, ethical, and practical implications. By understanding the constitutional requirements, implementing effective treatment solutions, and following strict rules and policies, correctional institutions can move forward towards a more humane and effective system that upholds both the justice and human dignity.